Can Tier 3 police officers apply prior non-police service toward their retirement eligibility? To find out, you have to read Lynch versus City of New York, but it's 11 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Lynch versus City of New York, published by the New York Court of Appeals on May 23rd, 2023. The citation for this case is 2023 New York Slip Opinion 02753. The issue in this case is whether Tier 3 police officers can apply prior non-police service to become retirement eligible for the police pension fund. To understand the context of this case, you have to understand that the police pension fund is the retirement system for retired police officers. And there are different categories of retirement benefits. Originally, there was just retired police officers. But then in 1973, they created Tier 2. And in 2009, they created Tier 3. So if you were a police officer before 1973, you were Tier 1. If you were a police officer between 73 and 09, you were Tier 2. And officers who started after July 1st of 09 are Tier 3 police officers. And to find out the benefits that they're entitled to, you have to look at different areas of the law. Originally, the pension fund was set out in Administrative Code 13-214. And then when they created Tiers 2 and 3, those were not put into the Administrative Code as amended. They created new law under the Retirement and Social Security Law, the RSSL. So you have to look at multiple places to find out what kind of benefits police officers are entitled to, depending on which tier they belong to. So the one other thing you have to understand is that in 2000, so before 1976, the Administrative Code, right, which is what set out the law for the police pension fund, said that the officers could not be eligible for retirement until he or she served in the police force for a minimum of 20 to 25 years. So it's only police service that define the eligibility for retirement for police officers. And in 2002, so now I get to the facts. In 2002, there was litigation between the PBA, the police union, and the City of New York about what kind of prior service could be applied to become retirement eligible. And in 2016, the PBA, basically Lynch, who's the head of the PBA, the president of the PBA, commenced this action for a declaratory judgment saying that the state and the city are not properly applying the law because they're not allowing police officers who are Tier 3 to become eligible from their retirement using prior non-police service. So if a person was an EMS, an EMT, or a person was a teacher, a person did some kind of public service before they were a police officer, they want that to be counted towards the retirement eligibility. It goes to the Court of Appeals, and basically this is a quick one, but basically they just say, forget about the agreement in 2002, irrelevant to this. They say it's a straight application of the law. The law said that before July 1st, 1976, the Administrative Code said only police service applied for retirement eligibility. And under Article 14, Tier 3 members are allowed to obtain retirement credit to the same amount as previous members, Tier 2 members could have gotten credit. So you put those two together, and since Tier 2 officers could only receive prior police credit or credit for their retirement from prior police service, so too for Tier 3. And that's the case essentially of Lynch versus City of New York. Prior service that's not police or fire related will not work. It's got to be only police service. And that's the case of Lynch versus City of New York. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.